The fourth, you are John Guillory, the third,
Yes, John.
and you were here with Mr. Turk, your attorney, and the state's attorney is Mr. Boyd, I think. Right.
This is not a plea hearing. This is a warning shot. Two separate felony cases, both involving illegal firearm possession, and a defendant whose criminal history stretches back nearly 2 decades. Judge Stevens lays it out immediately. This isn't about one mistake, it's about a pattern. With habitual felon enhancements on the table, this case carries the kind of numbers that stop a courtroom cold, 25 years to life. And today isn't about guilt or innocence yet. It's about bond, danger to the community, and whether this defendant walks out the front door or straight back to his cell. Watch closely, because every word here matters.
Jeff, 1, 2, 3 convictions of illegal possession of controlled substance and unlawful possession of a firearm by a felon in 2007 out of the 252nd District Court of Jefferson County. Thereafter, those were all final. It is alleged that you committed the third-degree felony of unlawful possession of a firearm by a felon and were convicted of that on February 9th, 2009 in the 252nd District Court of Jefferson County, Texas. After that conviction was final, it is alleged in paragraph 1, 2, 3, 6 that you committed the felony of escape from custody, a second-degree felony, and were convicted of that offense in 2010 out of the 349th District Court in Houston County, Texas. After that conviction was final, it is alleged you committed the offense of unlawful possession of a firearm by a felon, a third-degree felony, and were convicted of that on December 14th, 2022 in the 252nd District Court of Jefferson County, Texas. So if all of this is found true, this is a third-degree felony enhanced as a habitual felon. You were looking at then no less than 25 years to 99 years confinement in prison or life imprisonment. You understand what you're facing in 24 CR 79.
Yes, I do, Your Honor.
In 25 CR 434, you are charged with a third-degree felony of unlawful possession of a firearm on or about December 14th, 2024. And then it goes on to allege, it looks like similar convictions that we just talked about.
Yes, sir.
And thus, this is a third-degree felony, though punished as though it were a same way. Because of the 2 or more prior convictions in sequence, you are charged as an habitual offender. In this case as well, you were looking at no less than 25 years to 99 years confinement imprisonment or life imprisonment. Do you understand what you're looking at in this case?
This is the legal pressure point of the entire hearing. Even though these are technically third-degree felonies, the habitual felon enhancement changes everything. Under Texas law, multiple prior sequential felony convictions allow the punishment range to jump dramatically, from a standard 2 to 10 years, all the way up to 25 to 99 years or life. That's not exaggeration, that's statute. The judge makes sure the defendant understands exactly what he's facing before moving forward. This moment isn't theatrical, it's constitutional. Courts must confirm that defendants comprehend the consequences before bond decisions or trial scheduling. So ask yourself, when the stakes are this high, should bond even be on the table?
The danger, and while he was on bond for this other case, he ended up committing a new offense. So they believes that he's a danger to the community for that. And ask that he not be granted a bond, or that if he is, that it's ask him to be like $500,000.
Anything the defense wants to say?
Judge, yes, sir. Mr. Guillory is currently employed at Federal Road Properties. My understanding, he does have a job waiting for him. They do need him back. He's the property manager, maintenance manager of several properties here in the area. His wife is here in support of him. He does have two other children at home. He does have a stable house, some stable employment. He is eager to have his court date and say that he is not guilty of what has been charged with. If there may be some legal issues in the mix that I'm assuming is a new topic, so granted to be addressed. He does have family in the area, and he is willing to accept the conditions of bond.
Here's where the courtroom splits sharply down the middle. The state points to a troubling pattern. The defendant allegedly committed a new firearm offense while already out on bond. From the prosecution's perspective, that's the definition of danger to the community. The defense, meanwhile, paints a completely different picture. Steady employment, family support, a home to return to, and willingness to accept strict bond conditions. This is the classic bond dilemma. Past behavior versus present promises. Judges aren't guessing here. They're predicting risk. And when firearms and repeat offenses are involved, the margin for error disappears. Who do you believe more in this moment? The resume or the rap sheet?
Is it the court?
Okay. You were charged in each of these cases with illegal possession. I'm sorry, with illegal possession of a firearm in each of these two cases. The court notes that your indictment go on to allege that you have 1, 2, 3 prior convictions of unlawful possessions of firearms by a felon. You have now picked up 2 more. I have read the probable cause affidavits and the 24 CR 79. It is alleged here, according to the probable cause affidavit, that the firearm alleged that you possessed illegally was in the waistband of your sweatpants. Okay. And then 25 CR 434. In that case, you were stopped and the Beaumont police patted you down and you had drugs in your left pants pocket. And then you were the driver of this vehicle and you were arrested. They searched your vehicle and under your seat was Smith & Wesson 380. All right. Your bonds are $250,000 in each case. In each case, if you post your bonds, because you're a habitual felon long ago, 3 convictions ago, if you happen to be able to post the bond of $500,000 on this, you must be in home confinement. You must have a GPS on you at all times. You cannot leave the house except for emergency medical care or food or work, and that's to and from directly the most direct route possible from your home. And you obviously would be on other conditions such as do not possess a firearm or commit any other criminal act. All right.
Judge Stevens ultimately threads the needle with a firm but controlled ruling. Bond is set at $250,000 per case, $500,000 total, paired with strict conditions, home confinement, GPS monitoring, limited movement, and an absolute prohibition on firearms or new offenses. This isn't leniency, it's containment. The court acknowledges the seriousness of the charges while preserving the defendant's right to trial. This hearing underscores a hard truth of the justice system. Bond isn't about guilt, it's about risk management. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.